of your Zoom screen. Fourth, during the webinar, if the time permits, participants will be allowed to ask questions directly. In doing so, please use the chat box feature in Zoom. Before we start, ladies and gentlemen, we will invite His Excellency Alfiano Tamala as Charge d'Affaires of the Permanent Missions of Indonesia in Vienna. Hello, good morning, His Excellency. If I may re-ask the question again. Good morning. Hello, His Excellency Alfiano Tamala. Are you here?
Pak, yes, Pak Labib, ya?
Yeah.
Okay. Hello, Pak, to His Excellency Alfiano Tamala. The screen is yours.
Thank you for the floor, Pak Labib. Dean of Law Faculty of Universitas Pajajaran, Bapak Dr. Andes Idris SHMA, Secretary of UNCITRAL, Ms. Ana Jubangke, Director for Legal Affairs and Economic Treaties, Bapak Syahda Guru El Samudra, Excellencies, distinguished guests, ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Good morning and good afternoon to each of you. At the outset, I would like to welcome all of you to this webinar personally. Your presence shows that there is a great interest from the Indonesian public on the issue of the United Nations Convention on Contracts for International Sale of Goods, commonly known as CISG. Allow me now to explain briefly from our perspective of the rationale of organizing this webinar. As one of the Indonesian institutions that regularly deals with UNCITRAL, we believe that there are many developments and informations on UNCITRAL and its worth sharing with our public back home. Thus, the primary aim of the webinar is to do just that, which is to disseminate UNCITRAL and its work that hopefully might benefit Indonesia in the future. Excellencies, distinguished guests, ladies and gentlemen, Indonesia trade has been one of the essential elements in improving Indonesia's national economy and welfare, especially in this current situation of COVID-19 pandemic. As a result of this situation, many strategic policies are being implemented to ensure Indonesia's smooth practice of international trade. The first example of these strategic policies is through the enactment of Job Creation Law in 2020. This law allows Indonesia to revise more than 70 existing laws to streamline red tape and attract higher trade and investment transactions, which eventually drive economic growth. The second example is by forming various international trade agreements with other countries as part of its economic diplomacy, which are expected to further increase trade and investment activities. For those strategic policies to be implemented effectively at the technical level, it is our view that the government of Indonesia needs to take advantage of the various international regimes or facilities currently available, such as the CISG. Speaking about CISG itself, it is important to mention that CISG is arguable one of the significant achievements of UNCITRAL. The reason is that CISG tries to fulfill the international community's need to have a uniform and fair regime for the international sale of goods. Thus, it might be beneficial now for Indonesia to revive the discussion of joining as a party to CISG. Furthermore, we fervently hope there will be a more similar events as today in the future, so that CISG becomes a public discourse in Indonesia. Apart from the CISG, it is worth mentioning that Indonesia has an opportunity to have concrete work and mutually beneficial cooperation on the issue of international trade law with UNCITRAL. In this context, the permanent mission of Indonesia in Vienna stands ready to assist Indonesian stakeholders in grasping this opportunity. Excellencies, distinguished guests, ladies and gentlemen, I wish to dedicate the last part of my remarks to convey our sincere gratitude to our partners who help us make this webinar possible today. We would like to thank our co-host, Bapak Idris, Dean of the Law Faculty of Universitas Padjadjaran, and his team for your willingness to collaborate with us in this webinar. Then we wish to thank also Ms. Anna Jubampret, Secretary of UNCITRAL, and other distinguished representatives of UNCITRAL, Ms. Caroline Nicholas, Mr. Jose Angelo Estrella Faria, Mr. Luca Castellani, and Ms. Atita Cominder for your availability to participate in our webinar today. The views of representative of UNCITRAL will surely allow participants to gain valuable information on UNCITRAL in general and CISG in specific. It is our hope that this mutual cooperation would be sustainable and closer in the upcoming years. Lastly, I wish to convey our appreciation to Mr. Shahada Guru El Samudra for being able to deliver remarks in this webinar. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to His Excellency Alfiano Tamala for their wonderful remarks. Next, I would like to invite Dr. Idris SHMA as the Dean of the Faculty of Law, Universitas Padjadjaran. Good afternoon, Dr. Idris.
Yes, thank you, MC Labib Wajib. Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. All the prizes and thanks be to our God, the cherisher and the sustainer of our wood. Good evening, for ladies and gentlemen, especially for special and great international speaker from UNCITRAL. Of course, I would like to say so much to my colleagues, to International Business Law Department, Padjadjaran Law School, Ibu Prita and the gang, Pak Mursal, Taufik, and of course the other members. And of course, this evening we are very happy because the department has successfully invited international parliament speaker from UNCITRAL. So before that, I would like to thank so much first to Sasda Apes, Ambassador Your Excellency, Mr. Alfiano Tamala. Thanks, Pak Alfiano. Success and sehat di sana. Yeah. Because you have a duty from the state. Yeah. So the state will give us trust. Of course, we want to be the best person in our foreign cooperation. And also Pak Guru, Pak Syah Guru, Director of Legal Affairs Indonesia. Pak Guru, terima kasih, thanks so much. Because so far we have many times cooperated among us, between us, MOPA and of course Faculty of Law. Yeah. So many insights and science knowledge from MOPA, and of course our students are very happy. Yeah, they can internship in MOPA, and of course they are looking other science, other knowledge in terms of final assignment. Yeah. Special great thank you for, of course, what I mentioned before, that international prominent speaker from UNCITRAL, Miss Anna Jubin Bet. Thanks so much, Mr. Anna. Very happy we are here, so many attend in this international webinar. Miss Caroline Nicholas, thanks, Miss Caroline. Yeah. Miss Atia Commander, Head of International Regional for Asia Africa, yeah. And also Mr. Jos Angela Estrella Faria, Head Legislative Branch UNCITRAL Secretariat. Thank Jos Angela. And of course, Mr. Luca Castellani, Legal Officer UNCITRAL Secretariat. Yeah. And of course, my great student, thanks so much, and some participants coming from other university, other sector, other institution. Dr. Vita and almost the committee convention on contract, United Nations Convention on contract of our international sale of goods is one of the backbone, is one backbone to back up, to support international sale of goods. And the convention has already been ratified by more than 85 countries. But unfortunately, so far, Indonesia, of course, has not yet ratified. So this is opportunity for us, for my students. What are the urgent? What are the advantage and disadvantage if we will ratify the convention? And this is we can analyze for my students, not only for final assignment, but also for example, join author, join seminar, or other webinar. And CISG, I call it CISG, Convention on International Sales, is correlation with individual sale of good, because at national level, of course, we have civil law book, on the regulation, but how to regulate and how to overcome the gap between different countries in terms of a different legal system. For example, Article 7, Article 7 of the convention state that this is the most significant article, because the article will be one solution to overcome or to look for a solution, because what we are doing, if among countries or between countries has a different civil law or a different legal system in terms of sale of goods. At national level, I think so many countries, all of countries have its countries in terms of sale up by individual. But how to regulate or to conduct international sale of goods in terms of different national level with in terms of sale of goods. And I'm sure that this convention is bridging, bridging to overcome the gap, because the convention reflect how to be harmonization, how to be uniform in terms of sale of goods. Even the countries has a different system in terms of legal for the international sale of goods. So I think this is a great international public lecture. I think will be given advantage for us, for our students. So thanks so much for the foreign speaker. And of course, this is the first of all, this is the first time to meet and to get knowledge from the speaker. But also this is the initial, this is the beginning for the next cooperation. So I hope Department of International Business Law will start to cooperate significantly, to cooperate tightly between UNPAD and UNCITRAL. Okay, ladies and gentlemen, I think we hope to attend. Please, we can consume the material from the speaker, and of course, this is very, very important for us. Keep spirit for my student. Keep healthy. Keep fighting to get what you want. For example, if you want to be diplomat, maybe you can ask to ambassador to Pak Wahyu. And but how to be international lawyer in terms of, because international trade is very, very important. I'm practically saying that no state will be a bigger or a big state without a trade. So the trade is the most important for us for international cooperation. Okay, thank you so much again. Assalamualaikum warahmatullahi wabarakatuh. Enjoy the lecture, enjoy the knowledge, enjoy the insight from the speaker, international speaker. Good evening.
Thank you, Dr. Idris, for the remark. Before we continue, we are going to have a brief photo session. All the participants are encouraged to turn on their camera, and I will lead the session for now, assisted also by the operator. So I will give a moment for everybody to turn on their camera for the photo session. Okay, let me check. Okay, I'm still giving time for others to open up their camera. Okay. Is there anyone else who wants to open it? Okay, in total we have two pages worth of participants who have opened the camera. So I will lead the session for now. Okay, everybody, smile at the camera. 3, 2, 1. Okay, for the second page. Again, look at the camera. 3, 2, 1. Okay, thank you. Ladies and gentlemen, next up, moving to our next agenda. Next, we will invite Mr. Syahda Guru El Samudra as the Director for Legal Affairs and Economic Treaties for MOFA Indonesia. Before we continue, I will read his CV. Mr. Guru graduated from Brawijaya University with a bachelor's in law in 1999. He then went on to pursue his master's in law in University of Indonesia, graduating in 2005. Since then, he has worked on a plethora of jobs relating to international law, such as being the Minister Counselor for the Permanent Mission of Indonesia to the United Nations and becoming the Director of Legal and Economic Treaty for Indonesia's Ministry of Foreign Affairs. Mr. Guru, good afternoon.
Good afternoon.
Okay, good afternoon. To the Honorable Mr. Guru, the screen is yours.
Thank you, moderator, Pak Labib Wasdi. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon and good morning to all of you in Vienna, Jakarta, and wherever you are right now. Allow me to begin by thanking Charge d'Affaires of the Permanent Missions of Indonesia in Vienna, Bapak Alfiano Tamala, and Dean of the Law Faculty of Pajajaran University, Bapak Dr. Idris SIMA, for convening this webinar and for inviting me to deliver these remarks. Then we are also thankful and greatly appreciate the presence of Ms. Anna Jobambri, Secretary of Ancitral, and her team for being able to work together and contribute to this webinar. Greetings also to all speakers, Ms. Caroline Nicholas, Mr. Joseph Aria, and Mr. Luca Castellani. I do hope that this mutually beneficial cooperation between Indonesia and Ancitral can be further strengthened in the future. Excellencies, distinguished guests, colleagues, ladies and gentlemen, similar to what happened all over the world, Indonesia is actively promoting international trade good practice. This is done with a view to enable economic growth, especially in the context of the overcoming the economic impact of the COVID-19 pandemic that has been going on until today. Moreover, as part of bolstering its economic diplomacy, Indonesia is also active in concluding and negotiating free trade agreements, commonly known as FTAs, with its trade partners. Currently, as you might be aware, Indonesia had more than 10 enforced FTAs, regional ASEAN or ASEAN Plus, and bilateral such as with EFTA. We also now in the process of ratifications of the largest mega trade deal RCEP, Regional Comprehensive Economic Partnership Agreement, as well as more than 5 FTAs still under negotiation, such as with EU and also with United Arab Emirates. In those FTAs, trade in goods has been one of the crucial elements that must be negotiated. In this context, it is becoming more relevant for Indonesia to consider using any international legal tools available that could help ensure those FTAs could be enjoyed at grassroots levels, including by its business communities. That is why the discussion on CISG is very timely for Indonesia. As of now, we understand that the CISG has 94 state parties, which is not included Indonesia. However, the number of these 94 state parties actually show signals. There is a big trust for the international community that CISG can assist countries and their business communities in integrating fully into global commercial practice. Furthermore, as we are all aware, the main feature of CISG is to provide a modern uniform, and fair regime for contract for the international sale of goods. Countries could potentially utilize this main feature to improve its ease of doing business index. It might help reduce legal barriers often faced by business in cross-border commercial practice. Nevertheless, besides acknowledging all benefits that CISG could offer, it is also essential to understand any implication that a country could bear after becoming a party into the CISG. Before taking part in the CISG, Indonesia, like many other countries, should review its legal system. In addition to that, Indonesia should also ensure that there are adequate human resources capable of implementing the CISG in practice. This process takes time to be completed, and I think this webinar is crucial to become one of the milestones to continue the discussion to further identify the benefits and challenges if Indonesia were to accede to CISG in the future, as well as to continue past effort in 2013, whereas the Agency for National Law Development (BPHN), Ministry of Law of Human Rights, has conducted academic study for the accession for the CISG. We will surely take note of all the information, discussion, and suggestion presented today in order to prepare a comprehensive input on whether Indonesia should revive the process of acceding to the CISG and continuous long-standing effort of Indonesia's national law reform. Colleagues, lastly, I would like to echo the statement made by Charge d'Affaires of the Permanent Mission of Indonesia in Vienna just now about the opportunity to have mutually beneficial cooperation on the issue of international trade law with UNCITRAL that can cover many issues such like investment, not only CISG, and also maybe including the issue of transparency, arbitration, and all aspects that now being discussed within the UNCITRAL. Further, the Ministry of Foreign Affairs and of course the permanent missions of Indonesia in Vienna are more than happy to facilitate any Indonesian stakeholders, in particular the academics, to promote our cooperation with UNCITRAL. I thank you and enjoy the discussion. Assalamualaikum warahmatullahi wabarakatuh, and stay healthy to all. Thank you.
Thank you, Mr. Guru, for the speech that you have delivered. Okay, next we will invite Ms. Anna Jubong-Ple as the Secretary of UNCITRAL. Ms. Jubong-Ple holds a postgraduate degree in private international law from the University of Paris, Panthéon-Sorbonne, and a master's degree in international economic law from University of Paris and in political science from Institut d'études politiques. She now works as the Secretary of the United Nations Commissions on International Trade Law, or the UNCITRAL, and the Director of the International Trade Law Division in the Office of Legal Affairs of the United Nations. Ms. Anna Jubong-Ple, good morning.
Good morning to you all. Greetings to Mr. Alfiano Tamala, Chargé d'Affaires of the Permanent Mission of Indonesia in Vienna, Dr. Idris, SHMA, Dean of the Law Faculty of Padjadjaran University, and Pak Siada Guru Samudra, Director of Legal Affairs and Economic Treaties in the Ministry of Foreign Affairs of Indonesia. I'm very glad to join you here today to give you all our greetings from the United Nations Commission on International Trade Law, and more specifically, greetings from Vienna, where the Secretariat is based. I'm delighted to welcome friends of UNCITRAL to this special occasion to discuss the CISG opportunities and challenges for Indonesia. Many thanks to the Permanent Mission of Indonesia in Vienna for this initiative and for the seamless organization. And please allow me to give special thanks to the government of Indonesia for its continued support and its contributions, generous contributions to the UNCITRAL Trust Fund, which allows us to carry out activities such as the one we are organizing today, but hopefully many more in the future. Now, when trade takes place across borders, the legal uncertainty due to the diversity of domestic laws makes the outcome of commercial disputes highly unpredictable and increases transaction costs. One manner of increasing legal predictability is by promoting the unification and the harmonization of international trade law through its codification. And this is precisely what we are doing here in UNCITRAL. This is the mandate that the United Nations General Assembly has assigned to the United Nations Commission on International Trade Law. UNCITRAL instruments are very useful as they cover the entire lifespan of a transaction, starting with deal making, and that's where the CISG, today's focal instrument, is very useful. And as the contract of sale of goods is universally recognized as the backbone of trade, it's not surprising that the CISG is the most successful substantive uniform law instrument in this area. The predictability fostered by the CISG is well known, as it contains a complete balanced set of default rules covering the most common issues arising out of cross-border sales. The adoption and the use of the CISG contribute significantly to introducing certainty in commercial transactions and decreasing costs, thus facilitating cross-border commerce. Indeed, it's precisely the CISG's neutrality and the universal appeal that has led to its adoption in 94 states belonging to all regions, to all economic and legal systems. In Asia and the Pacific, recent adoptions have been made by Vietnam, Laos, and interestingly as well by North Korea. We're keeping our fingers crossed that there will be more regional developments in the coming months as the Philippines and Thailand are seriously considering adoption, and we're also participating and supporting their efforts in this direction. Now, the adoption by Indonesia has been endorsed by Indonesian researchers who stated that the majority of Indonesian companies that conduct international sales and the majority of Indonesian law firms recommend this ratification of the CISG. So the importance of having a uniform default contractual framework for complex cross-border supply chain management has also been highlighted in the recent to mitigate the effects of the COVID-19 pandemic, as Dean Idris was precisely mentioning. We therefore hope that today's activity will help pave the way for Indonesia's positive consideration of the CISG, and we of course stand ready in the Secretariat to further assist the government and the responsible agencies and ministries in this endeavor. Now, I leave you in the good hands of my colleagues, José Angelo Estrella Faria, who's the head of our legislative branch and principal legal officer of UNCITRAL, Caroline Nicolas, who heads our technical assistance section, Luca Castellani, a legal officer in the Secretariat and Secretary of Working Group 4 of UNCITRAL, and last but not least, Atita Kominder, the head of UNCITRAL's RCAP, the regional center based in Incheon, Korea, that works in the region. They will provide you more details on how we can further assist stakeholders on the CISG, but also broaden this discussion, hopefully in the future, to other UNCITRAL instruments and topics that UNCITRAL is working on currently. Thanks again very much to the Permanent Mission of Indonesia in Vienna. I wish you a very successful webinar, and I look very much forward to a next opportunity to meet you in Vienna or in beautiful Indonesia. Thank you very much.
Thank you. Thank you very much, Ms. Jubong Bre, for the remarks. Now we are entering the main part of the event. Next, we will hear from the speakers, and corresponding with the theme. I will list them down. First, we have UNCITRAL, its mandates and works by Ms. Caroline Nicholas as the head of technical assistance section of the UNCITRAL Secretariat. Second, we have Introduction to CISG Principles by Mr. Jose Angelo Estrella Faria as the head of legislative branch of the UNCITRAL Secretariat. Third, we have the CISG's benefits and policies by Mr. Luca Castellani as the legal officer of the UNCITRAL Secretariat. And lastly, we have technical cooperation and assistance from the UNCITRAL Regional Center for Asia and the Pacific, or RCAP, by Ms. Atita Kominder as the head of the UNCITRAL RCAP. These discussions will be guided by Dr. Prita Amalia, SHMH, as the moderator. But first, let me read the CV for Dr. Prita. Okay, Dr. Prita Amalia, SHMH, is the current acting head of the Department of Transnational Business Law. She has been a permanent lecturer at the Faculty of Law, Universitas Pajajaran, since 2006. Her research interests are in the fields of national and international arbitration law, international investment law, international trade law, international economic law, aircraft financing based on Cape Town Convention 2001, and infrastructure law. Dr. Prita, good afternoon.
Good afternoon.
Okay, I will give the floor now to Dr. Prita.
Thank you very much, Labib, for the introductions. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, good afternoon, and good evening for all the speakers and also all the participants of this prestigious webinar today. Before that, we would like to thank you for His Excellency Mr. Alfiano Tamala as a Charge d'Affaires Permanent Missions of Indonesia in Vienna, and of course to our Dean, Dr. Idris SHMA, for the very wonderful remarks, and to Director Guru Sahda Guru from the Minister of Foreign Affairs, and of course to Ms. Anna Zobangbrek as Secretary of the UNCITRAL. It's a great pleasure for us from Transnational Business Law Department to be hosted together with the Permanent Missions of Indonesia in Vienna to discuss for the today webinar topics about the CISG opportunities and challenge for Indonesia. And these sessions will be discussing about the CISG. And in these sessions, we have 4 speakers who will discuss further about the UNCITRAL, CISG, and of course the UNCITRAL recap to all the participants. We would like to welcome for all the participants on this webinar as well, not only from Indonesia, but I believe there's another participant from other university from other countries. So before that, we would like to bring attentions to this for all the participants to the CISG as one of the conventions that adopted on 1980 and entry into force in 1st January 1988. The purpose of the CISG is to provide a modern, uniform, and fair regimes for the contracts for the international sales of goods. And also CISG contributes significantly to introducing certainty in commercial exchange and decreasing transaction costs. As mentioned by Ms. Anna Zobangbrek, to what extent that Indonesia established numbers of research and publication for CISG in Indonesia, I think in this webinar, we would like to discuss further about the functions of the UNCITRAL and of course about the principles under CISG and also the benefits and the policy for Indonesia. These sessions will be divided into 2 sessions. First of all, that would be start by a speech by all the speakers. That we have 4 permanent speakers for this session. And after that, all the participants are welcome to join with this webinar by put your questions or concern using the chat box. So we would like to welcome all the speakers for these sessions. We have Ms. Caroline Nicholas. Good morning, Ms. Caroline Nicholas. Ms. Caroline will be deliver a speech about the UNCITRAL, its mandates and work. And before Ms. Caroline deliver her speech, Please allow me to read the curriculum vitae. Ms. Caroline Nicholas is a head of technical assistants and senior legal officers at the International Trade Law Division's United Nations Office of Legal Affairs, the UNCITRAL Secretariat. She has previously served as secretary to UNCITRAL Working Groups 1 and 3, leading UNCITRAL work on procurement and infrastructure development, investor-state dispute settlement, and online dispute resolutions. Ms. Caroline also teach and publish on UNCITRAL matters and public procurement law and policy at the postgraduate level in several United Kingdom and European universities. Prior to joining UNCITRAL, Ms. Caroline was an investigator in the United Nations Office of International Oversight Services, handled quality government claims at the United Nations Compensations Commissions, and practiced as a solicitor in the commercial law and commercial litigations in the City of London and Hong Kong. She has obtained a master's degree in philosophy, politics, and economics from University of Oxford, United Kingdom, and public procurement law and policy from Nottingham, United Kingdom. Without further ado, please joining me to welcome Ms. Caroline Nicholas with his speech on the UNCITRAL, its mandate and work.
Thank you very much indeed. And it's a great pleasure, as my colleagues have said, to be able to talk to colleagues in Indonesia and present some of our work on UNCITRAL. We're going to focus today on the CISG, and that's a very important element, as we've heard from various of the colleagues this morning, including from the Dean, from the Permanent Mission, and from the university itself. So one of the things I would like to do now is to take a little bit of a step back before we start looking at the CISG and give a little bit more context about UNCITRAL as a whole. We're looking at its mandate and its work, and why this is relevant is really in explaining the background to why, as the Secretary of UNCITRAL has said, and all of the keynote speakers, why Indonesia's engagement in international trade law and international commercial law reform is an integral part of engagement in the international trading community and the sort of benefits that this sort of participation can bring to a particular country. Now, I am going to try and share my screen. Now, I don't know whether that's possible or not. I have some slides. It looks like I can, but you will see I am a lawyer, not a technical person. So please give me a moment to.
Okay, it's present.
It's there. Very good.
Yeah.
I'm trying to put it on full screen, but it doesn't seem to let me do that. So I'm sorry you're seeing all the slides down the left, but my system will not let me change the format. Oh, okay. No, I have now. Okay. I have now.
This works. Okay. Yeah.
This is now just underlining why I'm a lawyer and not a technical person. So I'm going to talk to you a little bit about UNCITRAL and its mandate and work, and really starting with why we have UNCITRAL at all. As you've heard, it's the UN Commission on International Trade Law, and we've been going for 55 years as part of the UN's General Assembly. And that's really important. It's not part of the Security Council, it's part of the General Assembly. So it's founded on the basis that all UN member states have equal say in what goes on. And as Ms. Anna Jubanpret explained, its objective is to promote the progressive unification and harmonization of international trade law. You will see, and these slides will be made available to you later, there's a link to our website. And it's very important here just to say what we mean by unification and harmonization. What we're trying to do here is to say to businesses in different countries, if you use UNCITRAL texts in your commercial contracts and your commercial relationships, you will get the same results. And Anna talked particularly about the transaction costs that you might encounter in international trade. And they can be very significant, and actually say to businesses, well, why should we incur extra costs in trying to find out if we export from Indonesia to Austria, where I'm sitting, how those contracts would work? It's better just to export, not to export at all, or to export to a local country that we know about. So what we're trying to do is to take that barrier to international commerce away. And so it's a very much business to business focus. We don't do, as I will show you here, what we don't do is what the WTO does, which is setting the trade rules applicable between states. So if there's a free trade agreement between Indonesia and Austria, that would be sorted out at a bilateral level, and it might reflect what the WTO has in our various agreements. UNCITRAL isn't involved in that, but what UNCITRAL does is when you agree in one of those international trade agreements to treat each other's suppliers equally, UNCITRAL treat each other's businesses equally, UNCITRAL's rules are designed to allow you to make that a reality. So that's our role. And so we coordinate, we prepare what we call UNCITRAL texts. These are draft laws and conventions and so forth that you can use at your national level, and that's what the CISG is all about. And then the part of UNCITRAL that I'm involved in is to encourage countries to use our texts, because that's how the harmonization impact works. And very importantly, to make sure that they're all understood in the same way, because if people interpret what's in them differently, then the harmonization process won't result. So what are these texts designed to do? Well, we're part of the United Nations. So what we want to do is to support the Sustainable Development Goals. So what do? We enable international business to work. We facilitate international investment. And the particular focus is to support businesses to access international markets. And there's a particular focus these days on smaller businesses, micro, small and medium-sized enterprises, and businesses in developing countries and transition countries, because they have the most challenges in accessing international markets. And it might be through different areas, and we'll look at what some of those are in a moment. And it's because we allow businesses to flourish, whether they're selling goods, whether they're trading in services or investments, it's because we facilitate that we contribute to the Sustainable Development Goals, and as we've heard this morning, very importantly, to the post-pandemic recovery. And we look at the post-pandemic, but I must say, I think since we have been on the call this morning or this afternoon, Austria has announced that there is going to be a lockdown in Austria. So we're not yet at the post-pandemic recovery. And so we really do need to recognize that the challenges that businesses are facing during the pandemic are likely to carry on across the world for quite a while to come. And so we are particularly looking in UNCITRAL at how to use our tools to support businesses in the pandemic and afterwards. And as I mentioned, the point of our work is to cover the life cycle of businesses. So we start with how to set up a business, and here we focus on the small businesses, and we have tools, legislative tools and guidance to help businesses be established and registered and so forth. So once a business is started, what does it need? Well, it needs finance, and it needs market access. So this is where we develop tools to allow particularly smaller businesses at the moment to access finance through giving security over their assets. And we deal with commercial contracts and commercial sales. So we're going to look at the CISG, but as Anna also mentioned, what is a fact of life in commerce is that there are disputes. So the ADR that various speakers this morning have already mentioned. Most businesses these days trade electronically, and so electronic commerce and digitalization is very, very important to allow businesses to communicate internationally and do as much as they can online, because it's so much more efficient. We also deal with payment mechanisms, and that's all part of making your businesses flourish. And we do recognize that an important part of a flourishing business environment is to allow businesses to exit the market. That allows debt and capital that might be invested in them to become re-available in the market and to allow new businesses to grow. So this is what we mean about covering the life cycle of businesses and their commercial transactions. And we have texts to help all of these areas of the business life cycle. As has been mentioned, I lead the technical assistance work that UNCITRAL does, and I'm delighted to hear the expressions of interest in cooperation, and will be really pleased to follow that up after this webinar. What we're doing this morning is engaging in more or less a policy dialogue with Indonesia in a national, with some regional and international participation, to talk about why UNCITRAL's CISG may help Indonesia. That's what we're trying to do. We are raising awareness and raising understanding of the CISG and UNCITRAL more generally. If Indonesia then decides it wishes to reactivate its processes to join the CISG, we can help by providing technical assistance. That can include legal drafting. We can give more detailed policy explanations and how to tailor some of the provisions for national application in the Indonesian context. We can provide e-learning materials. Eventually, we hope in-person training, but that looks a little long away at the moment. And then when Indonesia uses UNCITRAL texts, we can provide even more detailed capacity building and so forth. And you're going to hear from my colleague Atita later on about the work of the regional center in that regard. And finally, if you go to UNCITRAL's website, we have a lot of case law on the CISG to help the interpretation process. So that's a package that we offer to states who want to use UNCITRAL texts. And our time in doing so comes without cost. This is our pleasure to help support states to use UNCITRAL texts. So I'm going to stop there. We will have our contact information in the slides that will be made available to you, and we are at your disposal at any time for questions. And in the meantime, I would like to thank you for your attention. Thank you.
Thank you, Ms. Caroline, for very informative and insightful about the UNCITRAL, its mandate and work. From the Ms. Caroline's presentation, we learned about how UNCITRAL established and how UNCITRAL legal stack also support the SDGs, especially for number 8, 11, 16, and 17. And I think it's really important to learn about what UNCITRAL has and support the business and commercial transactions. I believe that some of the participants also has access numbers of the legal texts, like international commercial arbitration is something familiar in Indonesia. And I think some of the students who join with the international moot court, and of course with the explanatory notes from the some of the UNCITRAL model law on international commercial arbitrations. Singapore Mediations Convention is something new for us, and Indonesia still learn a lot about that. And of course, another legal stack is really really useful for business and commercial transactions in Indonesia. Clouds, for your information, Ms. Caroline, we use Cloud as well to support our academic activities to give assignment for the student. And I think it really support us to understand further about norms in the UNCITRALs, like arbitration and of course CISG. Thank you very much, Ms. Caroline, for the presentations. And now we are moving for the second speaker. I think the second speaker would be Mr. Faria, Mr. Jose Angelo Estrella Faria. Hello, good morning.
Yes, good morning.
It's a great pleasure to meet you again.
It is my pleasure.
And welcome to our university virtually. And more than 10 years ago, you visit us in Bandung and meet with our student who joined with the Willem Zevis Moot Court competitions. And before Mr. Faria present his presentations, please allow me to introduce Mr. Faria for all the participants. Mr. Jose Angelo Estrella Faria is a principal legal officer and head legislative branch at the Secretariat of the United Nations Commissions on International Trade Law. He is a national of Brazil. He was a Secretary General of the International Institute for the Unification of Private Law, or UNIDROIT, between 2008 to 2017. A staff member of the United Nations since 1992, he was responsible for UNCITRAL work on privately financed infrastructure project and electronic commerce. He also supervised the work of Working Group 3 transport law between 2005 and 2008. He currently supervises all legislative work of UNCITRAL. He has published articles and books and taught various courses on legal harmonizations, commercial law, and international law. After we learn about the UNCITRAL, its mandate and work, Mr. Faria would present about the CISG introductions and the underlying principle. Mr. Faria, the screen is yours.
Thank you. Thank you very much for your kind introduction. And thank you for organizing this webinar, which gives me opportunity to see again so many dear friends that I had the pleasure of meeting in Indonesia several years ago, including particularly you, Dr. Amalia. It's always a pleasure to be in touch with you. I have shared with the organizers my presentation, asking them to kindly pass the slides for me, because it's easier from your end to do it. So I was asked to provide you with an introduction to the CISG, which of course, being a large instrument of more than 100 articles, is not something that I can do by analyzing each of these articles specifically. And I intend to do it in two parts. Next slide, please. So after a brief introduction on the rationale for development of the CISG and the process that led to the adoption of the CISG, I'd like to provide you a very brief overview of what the CISG covers, as well as its underlying principles, and then to highlight some of the aspects on the practical importance of the CISG and the status of its implementation. Next slide, please. As Madame Jubin-Brett already mentioned to you, and was also stressed by my colleague Caroline Nicholas, one of the purposes of the work of UNCITRAL, of the entire work of unification and harmonization of commercial law, is to reduce transaction costs and facilitate business. We know that contract law differs across domestic legal systems. But not only that, domestic sales law evolved very slowly over time and is still strongly influenced by the historical metrics rather than by the needs of modern trade. Indonesia is a very clear example of that, because you have not only the different sources of law coming all the way to Sharia, but also to Dutch Roman law, but you also have a very peculiar civil code, which is a very reflects the state of Dutch law at a particular point in time in the early 19th century. And this is the basis of our civil law. And of course, at that point in time, the law was not drafted, taking into account the needs of international trade, in particular, not the needs of the logistic requirements of today's trade, for instance, concerning payment, transport, customs clearance, and supply chain. All these were considerations that at that point in time were not in the minds of legislators. It also means that most domestic contract law were conceived for purely domestic transactions. And very few countries have special rules governing international trade that also take into account the particular needs of international trade. Now, these legal differences in outdated laws raise transaction costs, and I'll say in a moment why, and also make the outcome of commercial disputes hardly predictable. Next slide, please. Why are transaction costs raised, and why is the outcome of disputes less predictable? Transaction costs are raised first by the need to establish what is the applicable law of that contract. It's something that is established on the basis of the rules of private international law of the competent court. However, different countries also use different criteria for establishing the applicable law of a sales contract. In most countries, it would be the law of the seller. In other countries, it would be the law where the contract is concluded. In other countries, it might even be the law where the contract is actually performed. And what does that mean in practice? That means in practice that given these differences, From many of the very basic questions related to a commercial contract, you not know the answer upfront. For example, what makes a contract offer complete and whether it can be revoked up to the time it has been accepted by the offeree. Different legal systems answer differently that question. You have those systems that assume that the irrevocability of a contract offer, and others that provide for a broader possibility of revoking that offer as long as that has not been accepted. The same thing for the essential elements of the contract. Is the price an essential element of the contract? Yes or no? It used to be very strictly a fundamental element in France, and the legal systems influenced by French law, whereas other legal systems provide for more flexibility in determining the price. So we don't know in advance if we want to leave the price open or open for determination, whether that will be valid under domestic contract law. Another issue, does the contract need to be in writing? Can we have an oral contract? How do you modify a contract that was established in writing? Again, something to which different legal systems provide different answers. Can you refer to the negotiations to interpret the contract? And we know, for instance, that in civil law, that's largely possible. In common law, there are big restrictions to the use of peripheral information, especially related to the contract negotiations, to establish the contract and interpret the content of a contract. Can there be implied terms of the contract? Can a court conclude that that some or the other provision would have been included in the contract, even if the parties have not expressly agreed on that? Again, different legal systems provide different answers to that. Next slide, please. And these differences in domestic legal systems also affect contract performance, contract breach, and termination. For example, do we treat all sorts of breaches of contract in the same way, giving rise to a claim for damages? Or do we have specific remedies depending on the type of breach? And I see Dr. Amalia nodding because she's certainly very familiar with the old Roman solution, which is you have specific remedies for different types of breach. If the quality is less than what you promise, you may reduce the price. If you provide a good that is different from the one that was promised, you may reject the goods, etc. But what about other breaches of contract? Would they all give also the right to terminate the contract? Again, different legal systems would provide you different answers to that. Can I also suspend the performance of a contract if I believe that the other party will not be able to perform? For example, because I know that the company is going through financial difficulties. In many legal systems, you cannot, you have to perform. All you can do is that you can defend yourself against a demand for performance if the other party has not performed, but you cannot actively suspend performance. And some legal systems admit that. So again, another element which you don't know in advance. Another element of great uncertainty, can I compel the seller to deliver the goods promised? Or, so to speak, specific performance. We know that civil law countries are very generous in allowing for that. And in some countries, the court may even, sorry, next slide, please, just we move back. Some countries even allow a court to impose a penalty per day the other party is in delay in delivering the goods. Common law is generally opposed to specific performance and assumes the principle that all contract breaches will give rise to a claim in damages. Next slide, please. Also, can you terminate by simple notice? Do I need a court decision to terminate the contract? All these are significant differences, and that explain why the international community very early on put the harmonization of contract law, in particular sales law, on its agenda. It started with work begun in the 1920s at the International Institute for the Unification of Private Law, UNIDRAW, That work was interrupted during World War II, was resumed after World War II, and led to the adoption of two conventions at The Hague in 1964, the Convention on Sales Contracts and the Convention on the Formation of Sales Contracts. Both conventions had, however, limited impact for mainly one reason, is because they did not benefit from truly universal participation. They were drafted at the time where many countries are still colonies, so they're not represented, many of the developed countries in the developing world. Also, the countries of the so-called Soviet or socialist bloc and had not participated in the work, and not even the United States had participated actively in that work. Also, that's why this was placed on the agenda of UNCITRAL for a very big this was placed on the agenda for the UNCITRAL at the very first session when it established its work program. UNCITRAL then took over those conventions, which were scientifically very solid products, and then adapted them to make them more acceptable to a broader public, which is eventually led to the adoption of the CISG at the 1980 Vienna Diplomatic Conference. It entered into force significantly with the deposit of the instruments of ratification in 1988 of Italy, but also of China and the United States, all three countries at the same time. And as we've heard, it now has been ratified by 94 countries in the world. Next slide, please. Next slide, please. May I have the next slide, please?
Okay. Sorry, we got the connection problem, Bu Prita. Perhaps can you wait?
Okay. Then I'll continue and then see if you can catch up. All right.
Yes, please.
The CISG deals with contract for the sale of goods. It does not define what goods are, but is understood in the context of the CISG that it governs the sale of tangible, movable goods, which is also confirmed by some of the official languages in which the CISG was drafted, in particular the terms marchandises, mercancías in French and Spanish. What it does not cover are sales for personal or household purposes, or so-called consumer sales. They're excluded because of the special protective nature of the law applicable to consumer transactions. Also doesn't cover sales at auctions, at forced sales, which are always subject to a particular regime in most countries. Neither does it cover sales of negotiable instruments and securities, because those are typically instruments that represent immaterial rights. It also doesn't cover sales of ships, vessels, and hovercrafts, which in many countries are associated with immovable property. Neither does it cover electricity. As for the territorial scope of application, the CISG covers contracts for the sale of goods between parties who both have their places of business in different states that are both contracting states of the CISG. So a sale between Austria and Indonesia at this point in time would not be covered by the CISG because Indonesia is not a party to the CISG. However, if the competent court is an Austrian court, the CISG might apply if the Indonesian buyer sues the Austrian seller in Austria, and the Austrian judge would apply the rules of private international law of Austria and would determine that the applicable law to contract of sales is the law of the seller being in Austria, it would apply this CISG as the Austrian law of sales as contemplated in Article 1.1, paragraph B of the CISG. So either the two parties are in contracting states, or the rules of private international law would lead to the application of the law of a contracting state of the CISG. Next slide, please. I will now very briefly, before I turn to the fundamental principles underlying the CISG. Just to give an idea of what it covers. It covers, as I said, the rights and obligations of the party to a contract of sales. It has provisions not only of the sphere of application and excluded matters, which I've just alluded to, but has provisions on contract formation, interpretation of contract, and filling of gaps in a sales contract. On contract formation, the CISG, I ask for your indulgence that I don't have specific slides for each one of those topics, because that probably would have required me to speak for 3 hours at least on each of them. But very briefly, the CISG adopts a very classical understanding of the formation of contract. A contract is formed by the exchange of offer and acceptance. That part of the CISG then deals with the effects when you can revoke an offer up to each point in time, when they become effective, and it adopts a mixture of the dispatch and the receipt theory for a formation of contract. Basically, a contract is formed when the offer is the acceptance of the offer is received by the offeror, but a revocation of an offer is no longer possible after the offeree has already dispatched its acceptance. So you see it's a mixture of both systems on which most domestic laws are based. Also has provisions on interpretation and the gap filling that generally, again, combine subjective and objective elements of interpretation with a more generous treatment of the means that you can use for interpretation. The CISG does not exclude, as the common law countries normally do, the use of the resort to the contractual negotiations for the purpose of interpreting the terms of the contract. Then it has one chapter on the obligation of the seller and the remedies available to the buyer in case of breach by the seller. It's matched by a chapter on the obligation of the buyer and the remedies for breach by the buyer. There is, as for the substance, the central obligations of both parties, the CISG is not revolutionary because you don't need to be revolutionary. Sales contracts have essentially remained the same for thousands of years. The essential obligation of the seller are to deliver goods that meet the requirements of the contract and pass property to those goods. The obligation of the buyer to pay the price and, sorry, there's a typo there, and take delivery of those goods. There are, however, several specific nuances that the CISG provides to that. The CISG includes, for instance, an obligation for the seller to transfer goods that are free of third-party property rights, but also of intellectual property claims, which is very important in these days when manufactured goods, most of all, already contain a computer software component. So that's very important in the context of the CISG. Then the CISG has provisions on contract performance and the passing of risk. And here, allow me to stress another important point related to the CISG. You will not find in the CISG any provisions that indicate at which point in time the property to the goods sold will pass from the seller to the buyer. The reason being very simply that this is a point of big divergence among domestic legal systems between those systems that are based on a consensual transfer, and that's essentially most but not all of the Romanic system, including France and other countries, but property to the good would pass by the contract itself. And the Germanic and Scandinavian countries that would require the transfer of physical possession to the goods in order to effect the transfer of property to the goods sold, and the common law countries that would adopt a middle ground. That point being an impossible subject of harmonization, the CISG treats the matter simply by provisions dealing with who bears the risk of a loss or damage to the goods at which point in time of the contract. And essentially the CISG relates that not to the property, to the moment of passage of property, but to the obligations of delivery, and that are essentially related to the parties' agreement on the carriage of goods, and at which point in time the seller is deemed to have performed its obligation to deliver. Then it contains provision on contract breach, damage, and termination, and also provisions concerning the effects of so-called force majeure, or an exempting impediment, to use the terminology of the CISG, on the parties' obligations. Next slide, please. I would now like briefly to stress, and this is the main message of my presentation, the underlying principles and the international spirit of the CISG. There are certain numbers of principles that you can derive from the CISG. You will not find a list in the convention itself, or what are the principles that are underlying its drafting, but they can be extracted and inferred from many provisions. One of them is party autonomy. The CISG recognizes the freedom of the parties either to exclude the convention itself or to derogate from any of its provisions. This is in line with the general theory that contract law is not mandatory law in most countries, and so neither is the CISG mandatory. The parties can provide for a different allocation of rights and obligations from what is written in the CISG. Second, freedom of form. The CISG does not impose a writing for the formation of a contract of sales, even though countries may, under Article 96, those that wish to do so, may make a reservation imposing the written form for a contract. But most countries in the world have not done that. The CISG also recognizes trade customs and usages that are very important, because that means that the CISG fits well and supports the practice of merchants, for instance, in developing the Incoterms, in developing the UCP, the customer, the uniform rules on customs and practice for documentary credits, and several other usages that are applied and are used in international trade. And the CISG recognizes that the parties may even be bound by them if they are generally observed in the trade, and the parties ought to have known of their existence. One very important principle of the CISG, and one that goes in the direction of the international spirit of the CISG, is that the CISG embraces the philosophy of preservation of contract. The CISG does not make it too easy for a party to terminate the contract. In fact, it reduces the right to terminate to instances in which the other party has committed a fundamental breach of contract. The reason being very simply, you may wonder, why is it the CISG tries to bind me to a contract if the other party is in breach? Is the CISG recognizes, however, that an international contract is very difficult to undo. You know, goods have been shipped from one country to the other. Credit has been given by a bank. You have insurance arrangements, carriage arrangements. All these peripheral contracts are very difficult to undo. So the CISG does not make it too easy for you to do away with it. It provides remedies for dealing with difficulties that arise in the contract and limit termination to fundamental breach. And in doing so, the CISG it stimulates the parties to find a mutual amicable solution to the problems, for example, by permitting the cure of defective performance, or allowing a party to reduce the price, or even for admitting the possibility of a substitute sales, and then provided that the party in breach would be liable for any damage caused. Coming to damages, CISG also embraces the general principle of mitigation of damages. That is, even if you are the innocent party in the case of breach, you cannot simply let the goods rotten in the harbor. You have an obligation to preserve them if they are then supposed to be returned to the seller. And if you are the buyer and you have received goods that perhaps not conform to what you wanted, again, you may then resell them to someone and get the price difference rather than simply saying, I'm returning all the goods. So principle of mitigation of damages, you have to do what is reasonable within your sphere to reduce the damage caused by breach of contract. And lastly, also the CISG recognizes, however, that parties cannot be bound to do the impossible. And if they are prevented from performing by an unforeseeable, unexpected event beyond the consequence of which they cannot control, they would not be liable for damages. Apart from that, however, the CISG recognizes the principle of full compensation for damages and all damages that were foreseeable to the party in breach at the time it committed a breach of contract. Next slide, please. I will now very briefly stress these points of the practical importance of the CISG. Contracting state, and I understand that my colleague Luca Castellani would also pick up on some of these points to make his remarks on the usefulness of the CISG for a contracting state. But the current countries that have ratified the CISG represent about 80% of the world's trade in goods, which is quite a significant amount. The CISG offers an alternative for purely domestic law, for instance, when parties are reluctant to accept a contract that is governed by a law that is unfamiliar to them. It is a flexible instrument that the parties can adapt to their needs because it recognizes ample freedom of contract. And last but not least, is entirely in line with industry self-regulation because it accommodates the use of trade usage and customs and even makes them mandatory. Next slide, please. So here you see just a map with the CISG, and I show this map to indicate two things. One, you have a white spot in continental Europe, which has gladly been filled recently with the entry into force of the CISG in Portugal. And we still have, when you move towards the east and the Pacific region, you see that you have a large white gap above Australia, and you hope that this seminar will contribute for perhaps in the future for filling the gap with a beautiful blue in our new chart. So with that, I conclude my remarks. I thank you very much for your attention, and you are welcome to visit the UNCITRAL website for more information on the CISG. Thank you all very much.
Thank you very much, Mr. Faria, for very comprehensive about the conventions, the contracts on international sales of goods. I think some of the participants admire to learn further of each articles from these conventions, as we learned that this convention has numbers of the specific norms. For example, fundamental breach is something that regulate in our law, in our Indonesian law, of course, with the remedies. I think a specific different conditions, different remedies that provided by the CISG. And I think some of the participants also who participate in the William Civil Smooth Court competition is familiar with some of the norms in the CISG. And I think some of the contents of the CISG it's really interesting to learn further. And from these conditions, I think the purpose of the CISG to uniforms of the sales of goods contract, not only for both in all this law system will meet. And of course, in Indonesia, hopefully we have the same hope with you, Mr. Faria. Hopefully this webinar could give a contributions on what Indonesia step to for the CISG. So many scholars from Indonesia lecture and student research on the CISG and comparing with our system, our law that we have currently. Thank you very much, Mr. Faria, for the very insightful presentations about the CISG introductions and underlying principles. We learned a lot about the substance of the CISG. And moving on to the third speaker, as mentioned by Mr. Faria, Mr. Luca Castellani. Good morning.
Good afternoon. Good afternoon. Thank you very much.
Okay, thank you very much.
If you don't mind, in the interest of time, I will just move on with my presentation. I would like to thank the organizers and all of those who have spoken so far, but in particular, my colleague Angelo Faria, who has already explained very clearly and in detail many of the things that I would like to say. So for me, it will be very easy. I will just pick up on some of the things that he said.
Okay.
And I will maybe repeat them or give a different angle to them. But let me first share my presentation.
Please, Mr. Luca.
I take it that now you have my presentation on screen and everything is good.
Yes, it's right.
Thank you. So the starting point, we have said it already many times. What is the CISG? It's a treaty. It's a treaty that has been drafted in a manner so that it is compatible with all legal and economic systems. It has been adopted already in 94 states. We will come back to this, but I would like to stress that if we look at East Asia as a geographic region of economic interchange, when we see that a number of important countries in East Asia have already adopted it, like Japan, Republic of Korea, China, Singapore, Australia, New Zealand. So we have all the big economic players in the region already there. And it is true that in theory, and we will see why I say in theory, it applies already to more than 80% of international trade in goods. And its mission statement is to provide a modern, efficient, and effective legal framework to accommodate the commercial needs of the parties to the contract of sale of goods, but also international trade customs and usages. And here the mind goes to Incoterms. As we know, in every international sale contract, there is always the choice of an Incoterm to define how the price is made. For instance, what are the terms of delivery and so on and so forth. It's important to bear in mind that CISG has been written also having these customs, usages, and practices in mind. Now, the first point, and I will highlight some selected issues. I will not give a comprehensive overview that was already given by Angelo. Angelo has mentioned the scope of application. Now, here we have something really interesting because there is sometimes a misunderstanding on the nature of the CISG. The CISG is an enabling treaty, but it's not a treaty of mandatory application. So we see here that we have the classic definition. It applies to contract of sale of goods between professionals. So we exclude the consumers. And these professionals must have a place of business in different states. Then the first mechanism is very simple. If all the parties have their place of business in a contracting state, or alternatively, if the rules of private international law that apply point at the law of a contracting state. Now, we know Indonesia is not yet a party to the CISG, but we also think that because of the second rule, that is to say the application of the law of a contracting state, or because of the choice of the parties for applicable law, many of the sale contracts concluded with business in Indonesia may already fall under the scope of the CISG. For instance, in the region, it is common to have arbitration clauses, let's say with arbitration in Singapore, and Singapore law applies. But since Singapore law includes the CISG, if it is a contract for sale of goods, then the CISG applies to that contract. And it's really important that business people know that, because they are making already a choice to use the CISG. Now, this mechanism is very simple, very clear, and it gives a high level of predictability on the applicable law. But at the same time, and here comes the magic of the CISG, what makes it so special. It's very clear from the text of the CISG that the parties to the contract may exclude the application of any provision. This gives a lot of flexibility to the parties, but it also means that the parties are free not to use the CISG, but because of CISG, they are free to choose the law they want to apply. And so the CSG is used as an enabler, not only of the use of the rules of the CSG as default rules, but also of the use of any other rule that the parties decide to agree upon, because they believe these rules are better for their needs. This is a huge improvement in the direction of establishing the principle of party autonomy in international trade and to override limits in national law. Why adopt the CSG? Well, we have two options. As we know, some contracts for international sale of goods have a choice of law. Often, the law chosen is the law of the party that is economically more powerful. Sometimes the parties decide to choose the law of a third state in order not to give any strategic advantage, because of course each party to the contract wants to have its own law. I say the choice of the law of a third state is sometimes a bit, I mean, it is a choice, but of course that means that the parties are equally ignorant of the law, which is not an ideal condition, because they choose the law of a country which is not of either party. Of course, it is much easier for the parties to say, well, you know what, we have the CSG, it's enforced in our countries, we agree on that. And so we agree on uniform law, which know it's neutral, which know it comes from the United Nations. It protects all the interests. We know what is in the treaty. We know what's in the case law. So that makes negotiating that clause much easier. But of course, there is the other scenario where the parties did not agree because they could not, or because they forgot, or because maybe they are small and medium-sized enterprises that have limited resources and limited access to legal counsel. There can be many reasons. And of course, if we have the CSG, it's much easier for us, because of what I said before, to ascertain what's the applicable law. And then no matter which tribunal we go to, we should have the same outcome, because it's a uniform text. So the same laws apply, regardless of whether we go to court in one country or in another. On top of these benefits, there is the fact that my colleague has already mentioned, that the CSG is specifically designed for long-distance transactions. This comes down to some really important principles. The first one being the principle of conservation of the contract. That is to say that in the CSG, it is possible to, I don't want to say terminate the contract, because termination is the result, but the words of the CSG has to declare the contract avoided. Only if there is a fundamental breach, which means the contract does not have any more an economic meaning for the party. But otherwise, the CSG is a mechanism of adjustment of the contract. And why so? Because long-distance transactions are very costly. We have a cost for transportation, cost for foreign exchange, cost, and if we undo the effects, then we have the same cost, and it's a net loss, not just for the parties, but for the economy. So that's why we have a principle of conservation of the contract. We have a range of remedies, as my colleague already said, which really give us the possibility to find the best solution to that given problem. We have also a general good faith rule that has some applications, like the duty to mitigate. That is to say, if one party is breaching the contract, the other party has nevertheless a duty to mitigate damages in the common interest, not only of the parties, but also more generally of the economy. We have flexibility in terms of freedom of form, and then, and my colleague has already mentioned, we have a principle of uniform and autonomous interpretation, which means that the CSG should be interpreted not in light of domestic law, but in light of its own principles, so that no matter whether it is applied, the outcome of the decision is the same. And as I said before, because we have so many materials available on the CSG, the parties can manage the contract better. Many people focus on litigation and dispute resolution. I say, before we do dispute resolution, let's do proper contract management, because proper contract management is a key to having happy parties, to get the economic benefits we want from the contract, and also to prevent any dispute. But of course, if there is a dispute and we are clear on which law applies, the settlement will be easier and faster. Now, what are the challenges? Some criticism. Well, the CSG is not adopted by all states, but it is adopted by 94 states. And I must say, from my perspective, it's a bit ironic that the states that need the CSG the most are the smaller states. the developing countries. But in the CSG, we find all the big economies. So we have 17 out of 20 G20 countries, for instance. From that angle, the CSG now is helping those who need less help. So we need to make an effort to help also those who need more help, the developing ones. Then, of course, there is an issue of declarations. I come back to that. CSG does not cover all the matters, it is true, but it covers the very vast majority of the matters that come up in daily trade. There were some issues like validity of the contract or transfer of property, which were excluded because it was not possible to have a uniform position on those. But these are highly theoretical issues, challenging issues. But at the end of the day, what counts is, one, is the price of the goods paid? Two, are the goods in conformity with the contract? And these are the things that in the most cases come up in international trade. And the CSG is excellent at addressing these questions. There are some criticisms regarding the fact that legal notions are new and undefined. But then, of course, this is because of the need to ensure autonomous interpretation. We have to use concepts that are not related to any given legal system. Otherwise, this is not anymore neutral with respect to all of them. The absence of a supranational Supreme Court is another criticism. Again, I don't think that with a Supreme Court, the CSG would have ever managed to get to 94 states. Most of these international treaties are not under a dedicated Supreme Court, and yet there is a huge uniformity in interpretation, so maybe we don't need that. And then the limited use in practice, to which I will say simply that there are more than 5,000 reported cases on the CSG, which seems to me a real lot, and it shows that CSG is actually used in reality. In fact, as I said, the areas where there is not yet uniformity in the interpretation of the CSG are extremely specific and extremely limited. But the very vast majority of the articles of the CSG are interpreted and applied in a uniform manner. This has already been mentioned a few times. CSG itself is available in 6 official languages, in many more unofficial translations. I believe also in Bahasa it's already available. More than 5,000 cases reported, and you come to UNCITRAL, you find the cloud database and especially the digest of case law on the CSG, which is significant. It's more than 500 pages and gives you all the guidance on the interpretation of each article. So now, quickly, mindful of time, how does the CSG? Let's say these are an overview of benefits and also of possible challenges and why we can overcome them. But let's look at the CSG in a bit broader picture. Maybe what I will say now will be more of interest for professors and students, and maybe less so for the business people. There is a global trend towards promoting and upholding freedom of contract, party autonomy, freedom of choice of law and forum. In part, this is because we see business models which are really transnational, especially cross-border supply chains, where we need to be able to choose, if not the same applicable law, at least the legal solutions that are compatible across the supply chain. As I said before, the CSG is already an ideal tool in that respect because it is based on the 2 fundamental principles of predictability and flexibility. And we have now just completed this legal guide to uniform instruments in the area of international commercial contracts with a focus on sales, that explains precisely how the CSG interacts with other UNCITRAL texts and also texts of UNIDROIT of the Hague Conference on Private International Law, and how all of these come together in a manner which is comprehensive and coherent. This is available on our website, of course. I invite everyone to download it. To conclude, if we go to another level of abstraction, there are 3 dimensions of the CSG and of its use. As a treaty, as a model law, and also as an element of lex mercatoria. As a treaty, we say CSG is successful. We see significant economies joining in, but also smaller economies. I was very happy to see in the last 10 years progress in ASEAN. For a long time, only Singapore was a party to the CSG. We had Vietnam coming. More recently, we had Laos coming. A discussion, as it has been said already, is ongoing in Thailand and the Philippines. So it's just appropriate that we would have this discussion also in Indonesia. From the ASEAN perspective, it has been mentioned that CSG is particularly important for ATIGA implementation. Now, I have to say, Mr. Guru already has mentioned all of these, and RCEP and so on and so forth. So these are extremely important considerations, because one thing is to be able to trade under the free trade agreement, and the other thing is to know how to do it. And to know how to do it, one has to know what's the applicable law. And the CSG solves that problem. There are two main trends now with respect to the adoption of the CSG as a treaty. One is having new member states, and the other one is the review of declarations. Declarations are permitted by disrupt uniformity. Recently, we had several withdrawals of declarations in Europe and in China, which is particularly with respect to the written form, which hints at the fact that if Indonesia wants to adopt the CSG, we have to be a bit careful when deciding which declarations to file, because we might not need them. And then, of course, and I would like to stress it, there has been a very significant debate in Hong Kong about the extension of the territorial application of the CSG to Hong Kong. And the legislation has been passed 1 month ago in that respect. Now, this is legislation that applies only in Hong Kong, but we expect, of course, China, the central government of China, in due time to file a declaration of extension of territorial application, which means that the CSG will apply also to Hong Kong and not just to mainland China, and possibly eventually also to Macau. The second, and this is incredibly important for Indonesia, is the use of the CSG as a model. As you know, China, for instance, has just adopted the new civil code, and a lot of its content is based on the CSG and the UNIDROIT principles. So historically, the CSG is the most recent, the most modern, the most balanced global model for sales law. So we are talking here at looking at the provisions of the CSG not as a treaty, but as a model for national law reform. It's really important because, of course, Indonesia is a civil law country, but many of the commercial partners are in common law jurisdictions, and the CSG being a uniform text, it bridges the differences between the two. It has been adopted, for instance, in Brazil and in Vietnam, with a view to experimenting new notions of contract law and to see how those could influence the development of national law. And this did happen, for instance, in Brazil. I saw some decisions about national law, but making reference to principles which were in the CSG. And I think this is incredibly important for Indonesia because, of course, Indonesia, on the one hand, has a civil code which is now a bit dated, so to say, from 200 years ago almost. And so there's going, of course, an ongoing discussion on how to reform it. Let's say the CSG is what we call the low-hanging fruit, the one that we can pick easily and see how things work. And then we know it works very well already in international field, but we also become familiar with these notions, and then we can pick from there and put in the national law what we want. And this is really my very last slide. The CSG is also extremely important in Lex Mercatoria as a national law. That is to say, that law that some people believe exists and that is not related to any particular state or jurisdiction. In particular, this applies to international arbitration. You see it, of course, the CSG may be applied under its own scope of application or by choice of the parties, but also in arbitration, sometimes it's possible to use it as appropriate law, so-called loi directe, because the arbitrators have the possibility to choose the law that applies to the case. What is, I believe, extremely important here is that the CSG as an optional tool is nevertheless something that people who want to work in international commercial law must know. And that's also the logic behind the the fact that Hong Kong wants to have the CSG applied. They say this will not modify the sales law of Hong Kong, which is based on the common law, but it will give our professionals the possibility to know a tool that is extremely important and that is a resource. Because some clients will be better off by using the CSG, some clients will not, and we have to know when this tool is better and when a national law or the law of a third country is better. So again, I would like to finish this by saying the CSG is very far from being a treaty of mandatory application, but is as an extremely important treaty in order to give the possibility to traders to have a fair, equitable, modern, flexible tool. And the adoption of the CSG by Indonesia or by any other country will not mean to replace existing law, but will mean to put another tool in the toolbox that can be used in case of need and can also not be used when parties don't want to do that. Thank you. I believe I managed to use 20 minutes, more or less. I did my best. I thank you very much.
Thank you very much, Mr. Luca. It's really interesting, and we have so many information about the benefits of the CISG and then how the implementations of the CISG. So many key points that delivered by Mr. Luca, of course, especially for Indonesia, how CISG could also support the regional trade integration, namely A3, ASEAN Trade in Goods Agreement, and of course, there's a very interesting terminology, CISG as enabling treaty, and also how the CISG could be used also as a model law to reform our national. Hopefully, it's really important for Indonesia, Mr. Luca, in reform the contract law, and of course, especially about the contract sales of goods. Once again, thank you very much for very insightful presentations, Mr. Luca. And we are moving to the next speaker. We would like to welcome Ms. Atita Commander. But before that, please allow me to read the curriculum vitae of Miss Atita. My apologies to not introduce Mr. Luca before. Ms. Atita Commander currently is a head of the UNCITRAL RCA app or Regional Center for Asia and the Pacific, UNCITRAL RECAP, managing and technical assistant and capacity building programming available to over 50 states in Asia and the Pacific in the key areas of commercial law, numbers of the area including dispute resolutions, international contract practices, sales of goods, and so on. In that capacity, Ms. Atita coordinates with the governments and international regional organizations with respect to trade law, reform activities, and achieving the Sustainable Development Goals. Ms. Atita has 20 years of experience in the fields of international trade and economic law, arbitration, multilateral dispute resolutions, and the rule of law and development. Prior to joining the United Nations, Ms. Atita mainly advised and worked with numerous Thai agencies, including the Thailand Institute of Justice, Thai Ministry of Science and Technology, and Thailand Arbitration Center. She also worked for the Thai Ministry of Commerce in Bangkok and Geneva, representing Thailand in bilateral, regional, and multilateral trade negotiations, WTO dispute settlement, and treaty drafting. Admitted to the New York Bar, Ms. Atita has experience in both common and civil law traditions in the public and private sectors, and holds degrees from Harvard College, Georgetown University Law Center, and Harvard Law School. It's really interesting to learn Ms. Atita's experience, and looking forward to welcoming you in the next sessions. Ms. Atita, the screen is yours.
Thank you so much. Thank you for the very long introduction. I was just tired listening to it. But please allow me to share my screen. And while I do so, I would just like to call people's attention to the information that we've provided in the chat box, both the link to the UNCITRAL instruments, as well as the questions that Angelo has recently answered. So I hope you've seen that, and I hope you can see my screen well. Let's see, excuse me, for some reason, I don't think I can move the slides. I can't see how I can move the slides. Oh, I see.
Okay.
It's there. All right. And all right. So thank you once again, and greetings from the UNCITRAL Regional Center for Asia and the Pacific in Incheon, Republic of Korea. I'm Athita, and it is an honor to join you today to introduce the work of UNCITRAL in the Asia Pacific and my office, which we also nickname UNCITRAL RCAP. So Caroline earlier provided an excellent overview of UNCITRAL's mandate and its work, along with what Anna had mentioned. And my presentation will focus on another aspect, the non-legislative work of UNCITRAL, with a particular focus on the Asia Pacific region and examples of how Indonesia and RCAP could further collaborate. As noted, the mandate of UNCITRAL was designed to address concerns that conflicts and divergences arising from the laws of different states in matters relating to international trade constitute an obstacle to the development of world trade. So harmonization, such as that achieved through the adoption and uniform interpretation and application of UNCITRAL text, facilitates cross-border trade by decreasing transaction costs for users of the system and consumers. And to promote the use and adoption of UNCITRAL text, including the uniform interpretation, in addition to national legislation reviews, the UNCITRAL Secretariat undertakes two other main types of activities: the provision of technical assistance and capacity building, along with the collection and dissemination of information on developments in the field of international trade law. So the core of RCAP's work lies here, focusing on jurisdictions and stakeholders in the Asia Pacific. Technical assistance and capacity building activities range from organizing briefing missions for government agencies to assisting international development agencies in using UNCITRAL text in their law reform projects, to co-organizing webinars just like this one to raise awareness of and familiarize public and private stakeholders with UNCITRAL text and their use. Now, by way of background, RCAP is UNCITRAL's only regional center and is located in Incheon City, Republic of Korea. Our building where our very small office resides appears in the background. Supported by the South Korean government and also Hong Kong SAR China, including via secondees from the Korean Ministry of Justice and Hong Kong SAR Department of Justice, the regional center carries out UNCITRAL's mandate in approximately 60 jurisdictions in the Asia Pacific by promoting the use, adoption, and uniform interpretation of UNCITRAL text and providing capacity building in this regard. This year marks the 10th anniversary of UNCITRAL RCAP, and the Secretariat is very proud that since RCAP's establishment, the majority of Asia Pacific jurisdictions have adopted at least one UNCITRAL instrument, greatly contributing to legal harmonization to facilitate regional and global trade and investment. For example, approximately 40 Asia Pacific jurisdictions have adopted the model law on international commercial arbitration, with an increase of about 33% since 2016. The strong regional interest in enforcing contractual obligations via a predictable and neutral dispute settlement regime has also led to the successful launching of the Singapore Convention on Mediation, with over half of the 55 signatories and half of the 8 state parties hailing from the Asia Pacific. To raise awareness of UNCITRAL instruments and developments in the Asia Pacific, RCAP collaborates with a wide range of regional stakeholders, such as government officials, the judiciary, legal and business experts, academia, and regional institutional partners and development banks to further the progressive harmonization and modernization of international trade and commercial law. So, for example, RCAP has an ongoing collaboration with the Asian Development Bank to promote legislative reforms facilitating trade and investment in the region. Our most recently concluded activity was the 3-year technical assistance program for the reform of laws on international commercial arbitration in the South Pacific. And the partnership was very successful, with our cumulative technical assistance activities and legislative reviews leading to 4 new ratifications of the New York Convention in the Asia Pacific region, 3 of which are in the South Pacific, Papua New Guinea, Palau and Tonga, and subsequently Timor-Leste. So on the CISG, Luca has worked with RCAP to provide technical assistance and capacity building to Laos in the region, leading up to and following Laos joining the CISG in 2019. In addition, through RCAP, UNCITRAL has expanded its regional accessibility by delivering with its partners outreach activities in multiple United Nations and regional languages, including Chinese, English, Russian, Cantonese, Korean, Laos, Thai, and Vietnamese. Now, these slides show RCAP's flagship events that we host on an annual or biannual basis. In particular, RCAP collaborates with the Korean Ministry of Justice, Incheon City, KCAB International, to co-host a series of annual flagship events in Seoul and Incheon, namely the UNCITRAL Special Session for Asia Pacific Jurisdictions, the Incheon Law and Business Forum, and the Asia Pacific ADR Conference. We also co-host with the Hong Kong SAR Department of Justice, the UNCITRAL Judicial Summit every 2 years, and I believe some justices from Indonesia participated this year. In the wake of COVID-19, all activities have smoothly transitioned to hybrid or virtual formats and have expanded from a regional to a global outreach. So for participants who are interested in learning more about UNCITRAL and RCAP, I invite you to join our various events throughout the region, and details are updated on the link shown on your screen and also on UNCITRAL social media. So I urge you to follow our channels. For academics in the audience, and some have already reached out to me via the Zoom chat, I draw your attention to the UNCITRAL Asia Pacific Day flagship series. This is an annual series of academic activities that UNCITRAL RCAP co-hosts with institutions of higher learning on a wide range of UNCITRAL thematic issues to raise awareness of the international commercial legal landscape and UNCITRAL to law students and other stakeholders. This year's AP Day theme shown there is enabling MSMEs and assisting economic recovery through legal harmonization. And we invite universities in the audience to join these celebrations by visiting the UNCITRAL webpage or reaching out to UNCITRAL RCAP at uncitral.rcap@un.org. I note that for this year, an initial 34 universities and institutions across the Asia Pacific region in 13 jurisdictions have co-hosted or will co-host at least 20 activities with the regional center, which we expect would highlight the importance of MSMEs and other UNCITRAL issues to the global economy to several thousand law students and regional stakeholders. Now to students in the audience, and I know there are some lurking here, UNCITRAL in Vienna and RCAP in Incheon have internship application opportunities twice a year, usually in December and June. So, around mid or the end of next month. We have had successively diverse batches of interns at UNCITRAL RCAP and also in Vienna from all corners of the world. And we would encourage those interested to apply via the link shown on your screen. Now, RCAP interns undertake a wide range of tasks, including assisting in legal analysis of regional developments and awareness raising activities like the present one. So pictured are some of the moments captured with our previous batch of interns, some pre-COVID, some post-COVID. I think you can tell which ones are which. And with the pandemic situation, the internship is conducted remotely, but feedback from recent interns have been really positive with regard to this new mode of internship. Now, last but definitely not least, I invite all of you to take UNCITRAL's first online training course, Introduction to UNCITRAL, which was launched in July of this year. Developed in collaboration with the International Training Center of the ILO, this interactive and self-paced course introduces users to legal harmonization, UNCITRAL's methods of work, and how UNCITRAL texts contribute to the achievement of the Sustainable Development Goals. Currently available in English and also Chinese, the free modules are the first of a forthcoming series. The course is free of charge and available on the UNCITRAL website, and users will be able to enroll upon creating an account. An electronic certificate, I know many people are interested in that, is also downloadable from the platform for users who complete all 3 modules. Finally, UNCITRAL RCAP invites those of you interested in learning more to peruse our webpage to reach out via email and to subscribe to our mailing list via the QR code there. Thank you again to the Permanent Mission of Indonesia in Vienna, MOFA, and Pajajaran University for this honor. My colleagues and I stand ready to answer any questions you may have. Thank you very much.
Thank you very much, Ms. Atita, for very wonderful information about UNCITRAL RCAP. I think the very important information for the student is the internship in UNCITRAL is really interesting. Hopefully the pandemics will be end soon and all the students could join or apply for the internship. I think the information also important for all the academics, lecturers and students who conduct a research or to support the academic activities. Hopefully that it will be work for all the university in Indonesia, and of course, Transnational Business Law Department will be very to follow up the opportunity with UNCITRAL RCAP. Thank you very much, Ms. Atita. And we are moving on to the discussion sessions. I believe that numbers of the questions raised by some of the participants in this webinar has already responded by some of speaker like from Mr. Faria, but please allow me to once again to raise these questions in this forum. So all the speaker very welcome to respond. There's some questions from from Mark. It's about some questions about is it the governments or private sector not lobbying for it? What can UNCITRAL do to improve this? The committee trying to explore this to Mr. Mark. So the questions is in the concern of how the UNCITRAL could make sure the implementations of the CISG. Does any body or council established by UNCITRAL to bridging between the government or private sector in terms of the CISG or the UNCITRAL in general? Maybe I would like to invite some of the speaker. Miss Caroline, do you have something to respond this maybe? It's related to the UNCITRAL mandate maybe.
Yes, thank you. It's a really good question because what underlies the question is, even if Indonesia adheres to the CISG and takes all various steps to make it available and for contracts entered into by Indonesian businesses, people actually do have to use it. And so raising awareness and understanding that we're talking about today is so important. I think it's probably less a question really of lobbying, but more making sure people understand the benefits. And I know that there's been some discussion in the chat about, well, how does this work with national law? And clearly, from an UNCITRAL perspective, there would be a lot of benefits in having the same system based on CISG, whether you're talking about national contracts or international contracts, but that's a longer term objective. But clearly, the benefits to businesses of having the CISG for their international contracts are very, very important, because what it does is, instead of having arguments about whose law might apply, you just say, okay, we're not applying Indonesian law and we're not applying, say, Austrian law, we're using CISG, and you just agree, and then everybody can see what that's about. So that's the real understanding behind it, and making sure that business organizations, chambers of commerce and everything understand the benefits and can encourage people to use it is probably the best way of putting it. It's a very important aspect, so thank you for the question.
Oh, I'm sorry. Thank you, Miss Caroline, for the response. And I think it's really a wonderful response from a question raised by Mark, and I believe it's answered the concern. And we are moving for the second questions. Actually, the question is already responded by Mr. Faria. If I may introduce Mr. Bayu Seto is our head of Private International Law Lecture Association in Indonesia. And we work together to to develop the private international law in Indonesia. Maybe Mr. Faria, you would like to respond directly to Pak Bayu questions, please?
Thank you very much, Dr. Amali. I thought I had answered both questions in the chat to the entire public, but very briefly, one of them was the applicability of the CISG to public-private partnership contracts. And my answer was, as long as the contract is only a contract for the purchase of goods, obviously the CISG can apply. There is no impediment to it. However, most PPP contracts do involve provision of services, and the CISG does not apply to contracts where the preponderant part is the provision of services. You may well use the CISG to commission goods that need to be manufactured by the seller. That is possible, but the final product always has to be a tangible good and not services. In that case, for services, CISG would not apply. The second question was the relationship between the CISG and the Lex Mercatoria, and also the CISG and general trades and usages. As I said, the CISG is entirely compatible with general trades and usages, in particular the Incoterms. And if you look at the provision on the CISG on the delivery obligation of the seller, they leave ample flexibility for the parties to choose whatever Incoterm suits their needs. And depending on the Incoterms used, then the geographic point at a point of time where the seller fulfills its delivery obligations would vary, and the CISG accommodates that perfectly. The CISG even goes further, and Article 9, paragraph 2 makes it binding on parties any generally widely acceptable trade usage that the parties knew or ought to have known applied to that particular trade. So the CISG does uphold trade usage to a very wide extent. Now, as to Lex Mercatoria, that's, it's a very contentious discussion, and I prefer to espouse a more cautious or conservative view on that, and I only say the following. It is correct to say that the CISG contains many provisions that reflect principles that are widely applied across legal systems and by merchants in all countries and regions of the world, and therefore that the CISG reflects a number of principles that one could say belong to the Lex Mercatoria. Now, the CISG itself does not mention Lex Mercatoria. There's no reference to Lex Mercatoria itself in the CISG, but to the extent that Lex Mercatoria also incorporates generally applicable trades, usages, and practices that one could identify with the Lex Mercatoria, one could say that the CISG also can support Lex Mercatoria. And I will stop at that. Thank you.
Thank you, Ms. Faria, for very complete response to Pak Bayu questions. Pak Bayu, do you have something to respond maybe? It's a privilege for our head of Private International Law Lecture Associations. Please, maybe host could help Pak Bayu to unmute the microphone. Please, Pak Bayu.
Thank you. Professor Faria, I'm glad to see you again. This is my pleasure. Well, I have one other question. That is, this is a bit technical, but my question is like this. Is the CISG articles on contract avoidance essentially also cover hardship situation? Because usually we say that contract avoidance relates to force majeure, but is it and the CISG does not mention anything about hardship, which is mentioned in the UNIDROIT principle. So can we interpret that the articles on the CISG on contract avoidance may also apply to hardship situation? That's my rather technical question. Thank you.
Thank you, Pak Bayu. Hardship principle is one of the principles that famous in the pandemic situation. Mr. Faria.
Thank you very much. And I must begin by saying how pleased I am to see Pak Bayu again. And I still have very fond memories of the wonderful hospitality at Hughes University. And I look forward to being in Indonesia again before too long. I have to begin this question with one observational terminology, which is important. Different people understand different things by hardship and force majeure, and which is the reason why the CISG does not use any of them and refers to exemptions in Article 79. But if you understand hardship, and by the way, exemptions in the CISG, Article 79, is what UNIDROIT principles called force majeure, right? It's an impediment beyond your that was unforeseeable, is beyond your control, that prevents you from performing your obligation. Now, the UNIDROIT principles also deal with hardship, and hardship in the UNIDROIT principles is a slightly different thing. Is when hardship under the UNIDROIT principles is when the performance of an obligation has become excessively onerous to the obligor because of such an unforeseeable event. And what can happen in that situation? And the UNIDROIT principles, first they say excessive onerosity does not release a party from its obligations. But however, when that becomes really nearly an impediment, the party would have the right to demand negotiations to adjust the contract. And if the other party would be in an obligation to negotiate in good faith. And if the negotiations fail, either the court or an arbitrator can adjust the contract. We know that a few years ago, the Belgian Court of Cassation decided, interpreting the CISG, applied the principle of hardship, saying it was covered by the CISG. And this is a decision that has been heavily criticized in many countries and by many scholars. And again, forgive me for being perhaps conservative or overly cautious, but the position under the CISG is that the CISG does not address hardship in that sense, and there is nothing in the CISG that would create a right to a party to obtain an adjustment or modification of the contract. What the CISG, however, contemplates is that if this becomes impossible to a party to perform, and impossibility under the CISG may also include economic impossibility, that the performance of the contract would be ruinous for the party, right? Then the CISG would allow the excuse of that party's performance, or better said, the CISG would not make that party liable for the consequence of breaching the contract. But the CISG itself does not cover the possibility of contract adjustment or an obligation to on the parties to negotiate under those circumstances. So there is no express provision for hardship under the CISG. Thank you.
Thank you, Mr. Faria, for the response. Hardships always interesting to discuss, especially in these pandemic situations. We learned a lot, of course, in the implementation of some contract, for example, especially for the long-term contract. Thank you, very insightful. And we are moving to the next questions. Hopefully that's all the speaker could say is, I believe we could spend 15 minutes to discuss some questions that raised by the participants in the chat box. And next questions is raised by Adiana Bella Putri. This is our student from Transnational Business Law Department. And the questions is about CISG also contains general principles of law, which is the characteristics of lex mercatoria as in Article 6 and 7 of CISG. The CISG also included under Lex Mercator, since the background forming these conventions were formed based under the states parties' consents of the conventions, while Lex Mercator itself are separated from politics. Instead, it is designated for those who's directly involved in trade. I think Mr. Faria has responded a little bit about the Lex Mercatoria. Maybe I would like to invite Mr. Luca to respond these questions too. Mr. Luca.
Thank you very much. I totally agree with what Angelo said before, and I think that maybe there is a little bit of a difference here in the way I didn't want to say that CSG is a part of Lex Mercatoria, or that Lex Mercatoria exists as a concept in the theory of international business transactions law. I wanted to say that in the specific field of arbitration, it is possible to resort to certain texts that are well known by everyone because they are of universal application. And there are even mechanisms in the arbitration clause that formally validate the decision of the arbitrators to use those texts. So we see that for the CSG, we see that, for instance, for the UNIDROIT principles, even if the UNIDROIT principles have a contract law nature and the CSG has a treaty nature. So I would not so much focus on the idea that Lex Mercatoria does or does not exist. I would rather focus, and this was the intention of my intervention, on the fact that the CSG, although not of mandatory application, is a highly necessary tool for cross-border trade to improve predictability and to improve efficiency.
Okay.
I see that Angelo has raised his hand.
Yes,
Topic
maybe
that
Mr. Faria.
passionates him. He should have discussed that from the beginning. My approach
Please,
was very
Mr. Faria.
practical.
Yes, and now I just like to add one observation that Luca just said, which is again something that I'm obviously entirely in agreement with, is that in arbitration, the parties can choose not only state law, but they can also choose rules of law as the governing law of their contract or the law to be applied by the arbitral tribunal. And this phrase rules of law, it has become a term of art. It appears in the ICC arbitration rules, it appears in most arbitration rules around the world. And it is meant to include not only state law, but also what people call lex mercatoria or general principles of law, etc. Typically, a tribunal would use that when the parties are not happy to accept each other's legal systems, or they're not particularly developed, or perhaps they're unsuitable for the project. And the CISG can be chosen by the parties as the governing law, even if it's not enforcing the countries involved, by way of this possibility given to an arbitral tribunal to choose rules of law as the applicable law. That's all I wanted to add. Thank you.
Thank you. I think Mr. Luca also raised hand.
Yeah, and I just want to say one thing. This discussion on applying rules of law is very well illustrated in this publication. I don't know if you can see the title.
Yeah.
Which is, as I said before, is available on our website. And this part in particular was done with the Hague Conference on Private International Law. So you will see a lot of these very well illustrated in this publication for those professors and students and those who want to get into this. Thank you.
Thank you, Mr. Luca. I think there's some follow-up questions by Mursal Maulana, if one of our lecturer at the Transnational Business Law Department, after we discussed on how we could use CISG as a model law or a part of the national law, and Mr. Faria also mentions about how the state could use it as a choice of law. There's some concern from Pak Mursal. Is it possible to classify the CISG as a soft law instrument in relations to its practical effect rather than its legally binding nature? Ms. Caroline, you invited to answer these questions. Is it Okay, maybe host could help to unmute. Okay, please.
Thank you very much. My sound is coming and going. Can you hear me okay?
Yes, it's clear.
Okay. Could I when you repeated the question, I only caught the last part of it. Could you say it again, please?
Okay. Is it possible to classify the CISG as a soft law instrument in relation to its practical effect rather than its legally binding nature?
Okay. Okay. So actually, I think Mr. Faria is probably better to answer the detailed part of this. I will answer the first part and then pass over to him. Effectively, UNCITRAL texts are all have a soft law element in that nobody is ever required to sign up to any UNCITRAL texts. Their use is entirely voluntary. Now, I know you can classify things as hard law and soft law in slightly different ways, but even in UNCITRAL conventions like the CISG, there are opportunities to do things slightly differently. So that's the sort of bigger picture question. For the details about the CISG, I will pass that over to Mr. Faria because he's much more expert on that than I am. Thank you.
Okay, thank you, Ms. Caroline. Mr. Faria.
Thank you very much. Thank you, Caroline. Don't be overly modest because I'm not going to say anything that you would have not been able to say yourself. What I would like to say, perhaps just from a slightly different angle, besides the fact that no country is obliged to ratify the CISG, and in that sense is not something that is decreed by the United Nations and is directly applicable in all 193 UN member states, there's another element that's important, is that the CISG sometimes is used as if it were a soft law. Of course, as a treaty, once it is enforced, it is not soft law. It's applicable, directly applicable law in all those countries. But it's used as soft law in many respects. One of them, Luca alluded to, that's the CISG as a model for legislation, right? When a country uses the CISG as a source of inspiration, it's not obliged to do so. It uses because it's persuaded that the CISG is, contains good solutions that are a good basis for developing domestic law. Secondly, you have an interesting phenomenon that happens in Europe when the European Union develops regulations and directives that those are binding on the member states, but the basis for developing them was the CISG. And that happens in Europe. And that is an indirect reception of the CISG through a regional organization. The same happens, for instance, in NOHADA, an organization for the harmonization of business law in Africa, when they develop a uniform act on sales, and that is essentially the CISG. So the CISG can also be used as a soft law instrument. And finally, when an arbitral tribunal decides that the most appropriate set of rules for an international sales contract can be found in the CISG, in case, for instance, the parties it has happened in the past, contracts involving, for instance, companies in Iran and the United States, and neither the Iranian company nor the American company would accept Iranian or American law, and then arbitral tribunal would then apply lex mercatora, general principles of law. And typically, if it's a sales transaction, they will look at the CISG for a source of inspiration for the arbitral award. So the CISG was not meant as a soft law instrument, but it may very well be used as such. Thank you.
Thank you, Mr. Faria. It's really clear. Mr. Luca, do you have something to add? No? Okay.
No, that was very comprehensive.
Thank you very much. Even when we use CISG as a soft law or model law, it would be different if we ratify or bind to these conventions, because there's some limitations how we could implement the CISG. For example, if there's some contrary with our national law, we should also prevail some mandatory provisions, I think. Thank you. And I think we have a last questions before we come to the end sessions. The question is from Nicholas Tandrew. This is also one of our students. The question is, can CISG be excluded only to several clauses, or does the exclusions of CISG must to the whole contract? For example, can the arbitrations clause be excluded from the CISG while the whole contract is governed by CISG? If it is possible, can it be determined only by the interpretations of intent from the parties? Mr. Luca, maybe you have
Thank you.
something to
Well,
respond.
the text of the CSG is extremely clear. As I said before, the parties may opt out of the application of any of its provisions. The only one provision that may not be varied is in case there is a declaration on the use of the written form. So Article 11 and 96. Now I see the student is a very diligent student and he's following the evolution of case law. In particular, this has something to do with a recent decision, German decision, but also with the Wismut case. So there could be two things coming together. But that's a matter of the interpretation of the will of the parties, because the CSG gives the possibility to exclude any or all the provisions except that one. But then maybe the contract is not so clear, or maybe, you know, sometimes there are even offer and acceptance and there is not a single document. And so this is a matter then of interpretation of the will of the parties, which again, the CSG gives specific rules to do that. So these rules are meant also for international transactions, and for instance, it favors an objective interpretation because of the distance between the parties rather than a subjective one. There's many things to be said here, but I'm happy to see some influence here of most recent case law as well as of the case of the Wismut.
Thank you, Mr. Luca. Yes, I believe this is one of the cases from the mood, I think. So thank you. Before that, maybe I would like to invite Mr. Aitita. Do you have something in terms of how RCAP observe the state in Asia Pacific in terms of implementations of the CISG, and following numbers of the question that do you have something? Thank you.
Well, like Angelo had said before, we hope to fill the gap in the map above Australia. Really looking forward to that. Very interesting developments in the Asia Pacific region recently. You know, Laos joined a couple years before that, Vietnam. Also the same year that Laos joined, North Korea joined. So very interesting for all of us. So we hope to see more activity in the Southeast Asia region. As Luca had mentioned, both the Philippines and Thailand, my home country actually, are seriously considering the CISG. It will take some time. I've heard from a colleague in Thailand recently that, you know, they're getting there. It's taking some time, but they're getting there. So fingers crossed. Maybe Indonesia will get there sooner. A lot of interest today. If RCAP can be of help, if we can bridge anything between Vienna and government agencies in Jakarta, in Indonesia, very happy to do that always. So thank you very much.
Thank you, Ms. Atita. Yes, the Indonesia contributions to CISG, or the participate Indonesia to CISG, will be also support the harmonizations of the sales of goods in ASEAN, because we learned that only some countries from ASEAN has already being a contracting state of the CISG. I believe Indonesia learns a lot and has so many publications and research in terms of CISG and Indonesia we could collect. And I think government also give a concern in terms of next step for the CISG and Indonesia. Thank you very much, Ms. Atita. And I think we are in the end of the sessions, and it's really interesting, and I really enjoy being a moderator in the sessions. Really a lot of interesting topic discussed about the UNCITRAL and the CISG. So before we close the sessions, I think I would like to ask a closing statement from all the speakers, short statement from all the speakers, starting from Ms. Caroline.
Thank you very much, Ms. Prita. I think it's been a really, really interesting session, and I'm really grateful for the questions that we have been we've been given, because they are showing both not just a level of interest in UNCITRAL and the CISG, which is very gratifying. And we're really pleased that you're looking very seriously at using CISG in so many different ways. But moreover, you're asking the sorts of questions that are really important to make the use of CISG a success. And that for us is absolutely critical. So I'd like to just conclude by saying thank you for the opportunity to share some information with you. And as Anna Joubin-Brett would be saying if she was still able to be with us, we are really looking forward to the cooperation. You know where we are. Please ask us for whatever you need, and we'd be delighted to support you all. So thank you very much.
Thank you, Ms. Caroline. Mr. Faria.
Thank you very much. I would like also, as Caroline has done, to thank you, the organizers, the permanent mission of Indonesia to the United Nations in Vienna, and all the participants for the webinar. It's been a pleasure to be with you. That we look forward to supporting you in your consideration of the opportunity for Indonesia to accede to the CISG. Indonesia is an important country, is one of the G20. It's a large economy, but it's also, as you all know, a very complex country. And also one where naturally matters of commercial or civil law are not necessarily the highest priority of our parliament, especially in these days of pandemic. But exactly the pandemic provides us an opportunity for drawing the attention of the business community, the chambers of commerce, and others at the difference that it would make for a country like Indonesia if it were part of a uniform framework where some of the issues that come up during the pandemic concerning contract performance have already an answer that provides a framework for an efficient and effective allocation of rights and obligations and remedies for dealing with situations such as this. So we tend to say when God closes a door, it opens a window. Let's look at the pandemic in this case also as a window, and then perhaps that window would lead us to raising awareness also of the practitioners and business sectors. And last but not least, of the young practitioners of law. And here my respects to the teachers and professors who for raising the interest of them in it. We're very glad to support you on that. Thank you again.
Thank you, Mr. Faria. And we would like to invite Mr. Luca for the closing remarks.
Thank you very much. Very briefly, I would like to build on what Angelo has just said and to highlight that the discussion on the CSG in Indonesia has been very lively because professors have kept it going on. There are very good papers discussing in depth not only the content of the CSG, but also its interaction, what it can bring to Indonesian law. The CSG, of course, will always be parallel. It will not affect the national law, but it as we said, it can inspire law reform. And I want to say the students are very lucky to have all of these available, both in English and in Bahasa. And I want to encourage the students, especially those who are now engaged in the Wismut, because of course, the students of today are the CSG specialists of tomorrow. So we are already having the next generation of CSG scholars coming up. So they should feel very proud and honored of participating in this type of exercise. And they should feel the challenge that awaits them in a few years to maybe by then Indonesia will be a party to the CSG, so that will be just in time to contribute to the development of Indonesian case law on the CSG. Thank you very much again.
Thank you, Mr. Loka, and wish me luck for this next year Willem Davis Moot Court competitions. We always join in East Moot, so we are joining from Hong Kong, and every year the participant is coming more and more and become more compete on that. Thank you very much. And Ms. Atita once again for the closing statement.
Nothing to add, just our email address. Reach out with any additional questions at uncitral.rcat@un.org. Happy to connect with you. Thank you so much, everyone. Thank you. It's really been a privilege and a pleasure.
Okay, thank you very much for all the speakers. A great pleasure and honor for us to having you in this very prestigious webinar. And hopefully we would follow up for the next collaborations, since next semester we have the arbitrations and the international investment law. Hopefully we could have a same program, and we will follow up this opportunity to have a collaboration between UNPAD and UNCITRAL, of course, by support the permanent missions of Indonesia in Vienna. Thank you so much for the facilitations and everything to make this event possible. And I would like to say thank you also for all the participants who join and participate in this webinar. Also, your questions in the chat box is really means a lot for this wonderful webinar. Once again, Transnational Business Law Department looking forward also to collaborations with all the participants coming from the other university in other regions. Just please subscribe our YouTube channel, Transnational Business Law Digest. This webinar could also you can also access once again from this YouTube channel, and also our Instagram channel, Transnational Business Law UNPAD, for the next event. Thank you so much. Once again, it's a great pleasure to be a moderator today. And my apologies if there's some convenience in when we moderate this event. Once again, wassalamualaikum warahmatullahi wabarakatuh. Thank you very much. And I would like to pass this event to the Master of Ceremony, Labib.
Okay, thank you for the speakers and the moderator for the fruitful discussion. We would like to again remind the participants that the attendance list can be filled via the links sent in the chat box by the committee. Also, the committee has taken pictures throughout the webinar, including in the beginning, and the pictures can be accessed through our department's Instagram, which is @trans.business.law.unpad. I know it's quite a long name, so I'll repeat. It is @trans.business.law.unpad on Instagram. Okay, ladies and gentlemen, we have arrived at the end of the event. We would like to extend our greatest gratitude and appreciation to all speakers, the moderator, and all of the participants for being able to participate in this event. We hope that this event will prove helpful in deepening our insights regarding CISG for all participants. Lastly, I am Labib as the Master of Ceremony. Would like to apologize for any mistakes made along the way. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Santi Santi Om, Namo Buddhaya. Virtuous all. Roses are red. I like my teas with lime. Thank you for coming and see you next time. Good afternoon and goodbye, everyone.
Thank you. Thank you so much, Caroline, Mr. Faria, Mr. Luca.
Thank you so much. It's been a real pleasure.
Yeah,
Thank
keep
you.
touch
Look
by
forward to
email.
talking
Thank
to
you.
again soon.
Thank you.
Thank you.
Terima kasih, Pak Rahmat, Pak Adi.
Terima kasih, Pak Rahmat, Adi.
Thank you, Pak Gary, and all the committee for this webinar. Thank you, Pak Mursal. Thank you, Bu Helita, and also the student. Labib, thanks, Darian. A good